Hello, my name is Daniel Horowitz, and I am a criminal defense lawyer who represents medical doctors. I am board certified as a specialist, and I have represented physicians for over 3 decades. Today, I'm giving an overview of some of the most common federal fraud and financial abuse laws affecting the practice of medicine. Honest physicians can innocently violate these fraud laws, and when that happens, my job is to get you out of trouble. The fraud laws at their best protect patients, ensure the integrity of programs like Medicare and Medicaid, and keep our healthcare system honest. Unfortunately, these same laws, when applied to real-world situations, do not clearly define what conduct is legal and what is not legal. There are 5 major laws that every physician needs to know about. First is the AKS, the anti-kickback statute, the Stark Law, which is actually the physician self-referral law. The False Claims Act is well known by name, but its specifics are often cloudy. There are the penalty laws, which are called the Civil Monetary Penalties Law, and the Exclusion authorities. To a defense lawyer, a key factor that we look at is criminal intent, or at least wrongful intent. As I discuss these statutes, pay attention to when I alert you to the fact that even an innocent violation of the law can be punished. I'll start my more detailed analysis of these laws with the anti-kickback statute, or AKS. The anti-kickback statute is a criminal law that prohibits knowingly and willfully offering, paying, soliciting, or receiving anything of value called remuneration to induce or reward patient referrals or business involving services paid by federal healthcare programs like Medicare or Medicaid. Remuneration isn't just cash. It could be free rent, lavish dinners, expensive trips, or even excessive payments for consulting gigs. For example, if a lab offers a doctor free office space to refer patients for tests, that's a potential violation. The AKS is intent-based, meaning you have to knowingly intend to break the law, but ignorance isn't a great defense. Penalties are severe. Fines up to $25,000 per violation, up to 5 years in prison, and exclusion from federal healthcare programs. Plus, under the Civil Monetary Penalties Law, you could face fines of $50,000 per kickback, plus triple the amount of the remuneration. But here's the good news. The AKS has safe harbors that protect certain arrangements if they meet specific criteria. For instance, payments to bona fide employees, certain rental agreements, or personal service contracts can be structured to comply. The catch? You have to follow every requirement exactly. If you're unsure, consult a healthcare lawyer or check the OIG's safe harbor regulations. As a physician, you're a prime target for kickback schemes because you control referrals. So always ask, is this deal too good to be true? If it feels shady, it probably is. Next up is the physician self-referral law, commonly called the Stark Law. This one's all about conflicts of interest. It prohibits physicians from referring Medicare or Medicaid patients for designated health services like lab tests, imaging, or physical therapy to entities where the physician or their immediate family has a financial relationship, unless an exception applies. Financial relationships include ownership, investment, or compensation arrangements, like getting paid to consult for a lab. Unlike the AKS, Stark is a strict liability law. Intent doesn't matter. If you make a prohibited referral and the entity bills Medicare, you're liable, period. Stark penalties include fines up to $15,000 per improper referral, plus repaying any payments received. You could also face civil monetary penalties of $100,000 for trying to skirt the law. Exceptions exist. For example, there is an exception for in-office ancillary services or fair market value compensation, but they're narrow and technical. For example, a doctor who owns part of an MRI center can't refer Medicare patients there unless the arrangement fits an exception. The key takeaway? Always disclose financial relationships and get legal advice before entering referral-based deals. Now, let's talk about the False Claims Act, or the FCA. This law targets anyone who knowingly submits or causes to be submitted false or fraudulent claims to the government, like billing Medicare for services that never happened or weren't medically necessary. Knowingly includes actual knowledge, deliberate ignorance, or reckless disregard of the truth. A common violation is upcoding, where you use a billing code for a more expensive service than what was provided. For instance, billing a complex office visit when it was a quick checkup. The FCA has both civil and criminal components. Civil penalties include triple damages, 3 times the amount the government lost, plus fines of $5,500 to $11,000 per claim, adjusted for inflation. Criminal violations under 18 U.S.C. Section 287 can lead to imprisonment and hefty fines. Physicians have gone to prison for FCA violations, like falsifying medical records to justify unnecessary procedures. Whistleblowers can file lawsuits on the government's behalf and share in the recovery, which incentivizes reporting and costs you a fortune, because even if you win, you still have to pay your own attorney's fees. If you lose, the penalties can be huge. To avoid FCA trouble, ensure your billing is accurate, document medical necessity, and train your staff on proper coding. The Civil Monetary Penalties Law, or CMPL, is another tool used to tackle fraud and abuse. It allows fines and penalties for a wide range of violations, like offering kickbacks to patients, such as waiving copays to attract business, submitting claims for unnecessary services, or violating Medicare assignment agreements. Imagine that you have a poor population, and out of kindness, you waive copays. That might make you vulnerable to a CMPL violation. Penalties can reach $10,000 to $50,000 per violation, depending on the issue, plus triple damages. For example, a Minneapolis physician paid $53,400 for charging patients an annual fee that included Medicare-covered services, violating his assignment agreement. As you probably surmised, a CMPL violation often overlaps with other laws. This amplifies the penalties for things like kickbacks or false claims. Finally, the exclusion authorities allow the OIG to bar individuals or entities from participating in federal healthcare programs like Medicare, Medicaid, TRICARE, and the Veterans Health Administration. Exclusions can be mandatory or permissive. Mandatory exclusions apply for things like felony convictions for healthcare fraud or controlled substance violations lasting at least 5 years. Permissive exclusions cover a broader range, like misdemeanor fraud convictions, providing unnecessary services, or defaulting on health education loans. If you're excluded, you can't bill federal programs directly or indirectly, meaning your employer can't bill for your services either. This can be a career ender because it carries over even if you become an employee of a medical corporation. If you are concerned that you are in violation or close to a violation of any of these fraud laws, you should seek immediate legal advice. Remember that your attorney understands just how complex these laws are, and an experienced medical attorney will not presume that you acted with a criminal intent. These cases do work out without criminal charges or severe penalties being imposed. Do they always work out? Sadly, no. But with proper legal representation, you stand the best chance of success.
Daniel Horowitz is the leading medical defense attorney for doctors in California. His leadership in championing physician independence is legendary. If you need help, call Daniel at 925-283-1863. You worked years to earn your license. Let Daniel Horowitz help you protect what you have earned.